doing well. My name is Tseho Khailai, also known to you as Mapike_Mrs. G, and I am coming to you from my Lawyer's Corner once again. So welcome back to my Lawyer's Corner at my little corner of YouTube. So those of you that are new to my little corner of YouTube, on my little corner of YouTube, we talk mostly about my motherhood realities. I talk a little bit about my lifestyle choices, my lifestyle interests, makeup, skincare, healthcare, self-care, as well as my interests outside of that, like random things like gardening and what have you. But I have now established my Lawyer's Corner. On my Lawyer's Corner, I give you nuggets and pieces of information that basically will empower and equip you to know your rights. Right, so let's get into today's topic. Let's get cracking. Okie dokie. So today I wanted to talk about a topic that is very prevalent in labor relations, a topic that I think I get asked a lot of questions about. So today I'm talking about unfair dismissals, and particularly my focus is going to be on the procedure that has to be followed when it comes to dismissals. So very briefly, I will be referring to my notes from time to time, so please don't take offense when I look down from time to time. What is a dismissal? A dismissal really is a unilateral decision by an employer to terminate an employee's employment. In the reverse, a resignation is a unilateral decision by the employee to terminate their employment. The parties can come to a decision that is not unilateral, that is a mutual agreement by the two parties having taken certain factors into consideration and decide that the relationship is no longer fruitful for either of them and they can mutually terminate the employment contract. But a dismissal is a unilateral decision by the employer to terminate the employee's employment, right? It can be argued that it's not necessarily unilateral if the employer goes through certain processes, but it's still unilateral in that it's the employer's decision to terminate, right? For a dismissal to be fair, it has to be substantively fair and it has to be procedurally fair. The procedure is what I'm going to focus on in today's clip, but substantive fairness, very briefly, it refers to the reason behind the dismissal. Is it misconduct? Is it retrenchment? Is it incapacity? What is the reason behind the dismissal? That will speak to the substantive fairness, right? Procedural fairness, on the other hand, is also related to the substantive fairness of the dismissal because the process that is to be followed is in most instances, very much linked and very much related to the reason behind the dismissal, right? Let's take misconduct, for example. If an employee is being suspected of any misconduct and any investigation has come to the fore, or any investigation has been conducted in order to determine that an employee is guilty of or potentially guilty of a misconduct, the process that has to be followed is that the employer has the responsibility to make sure that the rules or the policies of that place of employment are clear, such that the employee can be reasonably expected to know when they commit an offense that they are breaking a rule or a policy or a provision of that particular employment place, right? For example, there are some rules that go without saying as a part of the common law. For example, theft. Theft is a misconduct, basically. Theft is against the law, and as such, in a place of employment, theft would be against the policy of the employer, right? The employer has also the responsibility to apply progressive discipline, right? If an employee has been transgressing or crossing the line in terms of certain policies, in terms of certain rules of engagement at the employment place. The employer has the responsibility to apply progressive discipline, issue out warnings, reprimand the employee, apply progressive discipline, and record them in writing so that the employee is aware that this process is being implemented in an attempt to correct incorrect behavior, and thereafter, once that is all done, prior to an employee being terminated for misconduct, the employer needs to follow a process of allowing the employee an opportunity to state their case and defend whatever reason is being presented as the reason for their dismissal. This process is followed in a disciplinary hearing. Now, before a disciplinary hearing can be held, the employer has to give notice to the employee that they're going to follow a disciplinary process in order to address the conduct of the employee, right? The employee must be given sufficient notice of the date and time and place of where the hearing is going to take place, as well as what charges are being leveled against them, right? There is no prescription in law per se that says what is a reasonable time that should be given for a notice to attend a disciplinary hearing. However, it has been accepted on multiple occasions that 48 hours is generally a fair amount of time to give notice to the employee in order to prepare for the disciplinary hearing, right? And the charges that are noted in the notice to attend a disciplinary hearing, you don't need to go into explicit detail, but you do have to give sufficient information for the employee to know what charges are going to be leveled against them, and in order for the employee to prepare their defense based on the information that has been given in the notice. The notice has to be explained to the employee, and it has to be you have to make sure that the employee understands the notice and understands their rights in terms of the notice that has been issued. Such rights can be documented in the notice itself. You give them all the rights that are pertaining to that notice itself, as well as the disciplinary hearing, so that they understand that in terms of the hearing itself, they do have certain rights, which I'm going to go into right now. So the Code of Good Practice, the Labor Relations Act Codes of Good Practice basically outline the processes that should be followed in a disciplinary hearing, and basically guide as to what can be done, what should be done, what should not be done in order for a dismissal to be fair in terms of its process. Right. Now, in a disciplinary hearing, the employee who is being accused, the accused employee, has the right to be represented at the disciplinary hearing. In most instances, you have the right to be represented either by your union rep or your shop steward, or an internal employee of the employer, like a colleague. You can be represented by a colleague. I do advise that employees be represented in disciplinary hearings solely because in most instances, when being called into a disciplinary hearing, it is emotional for that employee because it's a personal matter. And when being represented by another employee, it's not so personal to them. They're able to separate emotions from the facts. They're able to then present your case and articulate the things that you wish to articulate in a better setting as opposed to in an emotional way, right? The employee who is now being accused has the right for the hearing to take place in a language they understand. English is not most people's first language, right? And so the employee has the right to have the disciplinary hearing conducted in a language that they understand. If there need be, there has to be an interpreter who can interpret to the employee in a language that they can understand and feel comfortable to proceed with the hearing in, right? It is highly recommended that an employee be present at the hearing, because should you be given sufficient notice to attend a disciplinary hearing and you don't proceed, you don't show up, the disciplinary hearing can proceed in your absence and a decision can be taken. So it is very imperative that you attend your disciplinary hearing. If for any reason you are unable to attend the disciplinary hearing, state it to the employer before the date of the hearing so that you apply for a postponement. The employer cannot refuse a postponement for an arbitrary reason. So if you are unable to attend a disciplinary hearing for whatever reason, it is your responsibility as the charged employee to inform your employer of the reasons why you are unable to attend the hearing. Right. Whew, I left my water. I don't know why I left my water, but let's keep going. At the said hearing, the employee who is being charged they have the right to challenge the evidence of the employer. By challenge the evidence, they have the right to be presented with documents that they can challenge, and they have the right to cross-examine the witnesses that the employer will present at the hearing. So it is your right as an employee who is charged in a disciplinary hearing to challenge the evidence that the employer puts forward against you, be it documentary evidence, be it video footage, be it witnesses that will be called to testify. You can challenge that evidence and cross-examine and dispute whichever points that are not in your favor, which you want to show the chairperson that things should be seen in your favor. The employee also has the right to present evidence in their favor, in their defense, as well as to call witnesses that will testify in their favor. The employee must bear in mind that those witnesses who are called in his favor, the employer party also has the right to cross-examine. So in law, there's a term called the Audi principle. The Audi principle basically says that both parties must be given a fair and equal chance to state their cases, right? And this is a rule that must also be communicated in a disciplinary hearing, so that the employer and the employee both have a fair chance at stating their case. And finally, the employee who has been charged with whichever charges that bring to the fore the disciplinary hearing, whichever decision that is taken in the hearing, the employee has the right to be informed of that decision and informed of the reasons behind it. Right. Now, this is basically the process in a disciplinary hearing for a misconduct. There's certain other processes that can be followed in other hearings, such as an incapacity hearing, be it an incapacity for poor performance or for ill health or disability, permanent or temporary disability, or incompatibility with the job requirements. Now, there's a term that we use very often as labor lawyers or HR specialists. It's called a performance improvement plan. Prior to instituting a hearing, an incapacity hearing, the employer has the responsibility to follow through a process called a performance improvement plan, so that at the hearing they can show that they have followed a process whereby they supported the employee's performance, they helped them to try and improve the process or the performance, and document the time period within which this performance improvement plan took place, and the steps that have been followed in order to attempt to assist the employee in reaching the targeted outputs. Without that, at an incapacity hearing, without having followed that process, the dismissal for incapacity may be deemed unfair. I don't want to go too deep into retrenchments because I want to focus solely on retrenchments in its own setting, in its own clip, in its own lawyer's corner session, because there's so much information that goes into retrenchments that I want to afford it as much time as it requires. But let's talk a little bit about what to do, what steps to take in an event that you feel your dismissal has been unfair. In most instances, after a disciplinary hearing, the employee has the right to challenge the decision of the chairperson of the hearing by noting an appeal. The employer has the responsibility to outline to the employer what are the steps to take should they not agree with the outcome of the hearing, right? There's normally an internal appeal process wherein the matters ironed out in the disciplinary hearing will be sent to a more senior person, more senior than the chairperson, or whatever the case is, where the process or the policy has been outlined in terms of a process for the dismissal to be reached, the disciplinary hearing, the process to be reached in conclusion. Sorry, I just got distracted by somebody outside, hence I lost my train of thought. But the employer has to outline the appeals process so that the employee is aware of their rights in terms of appealing a decision of a disciplinary hearing, right? Once all of those steps, and let me say before I get to my next point, let me say in the appeal process, the employee cannot bring any new facts that were not canvassed during the disciplinary process. So you need to ensure, as an employee who is being called into a disciplinary process, that you canvass all your evidence and you put everything, be frank with the hearing, put all your evidence on the table, because should you then choose to appeal the matter, you cannot bring any new information that you didn't bring at the disciplinary hearing. Now, once the internal process has been exhausted and there's no more, you've reached basically the ceiling of appealing. Most employers have several steps of appeal before you get to the ceiling and can no longer send it to a more senior individual who will take account or who will take consideration of your matter. There is a forum called the CCMA, and in some instances there are bargaining councils that are specifically designated or dedicated to hearing disciplinary matters, industrial relations matters, employee relations matters, which have ended in an unfair dismissal. Let's park it at an unfair dismissal claim. This is where you refer your matter to. You complete a form called a 711 form, a form 711, and you refer it to the CCMA. In some instances, bargaining councils, depending on the sector within which you fall into. The CCMA is always the first step to take, because if there is a bargaining council that is applicable, the CCMA will inform you. Once you refer your matter to the CCMA, should you be claiming the matter is substantively or procedurally unfair, you will have to appear at the CCMA as an applicant. Your employer will have to be present at the CCMA as the respondent, and you will then get an opportunity first to try and mediate. The attempt will be first to try and find an amicable solution between employer and employee, where the two parties will have to either compromise in some instances to get to a middle point and to settle the matter, right? Now, if the conciliation or the mediation fails, that part is called the conciliation, where a commissioner will sit as an independent third party to hear both sides of the matter and advise you in trying to get the two parties to get to a common ground where they will settle the matter and resolve the dispute. Note that this process does in some instances require parties to compromise to get to a common ground of settlement. But in that way, the parties still have some control as to how their matter gets resolved. Now, if conciliation fails, the matter then gets referred for arbitration, right? Arbitration is more of a formal setting where the matter will be on record and the commissioner will have to take a decision based on the evidence that is presented at the arbitration. Now, this takes away control from the parties to get to a settlement that they can agree on, because the decision will be that of the commissioner. Unfair dismissals. If the employer is found to have dismissed the employee unfairly, the commissioner can find that the employer is liable to pay damages up to 12 months worth of the employee's salary for unfair dismissal. We will talk about automatically unfair dismissals, wherein the employer can be liable for up to 24 months of the employer's salary. So the CCMA takes very seriously matters that relate to unfair dismissals, because workers, like I said in my previous clip, I hope you did see my previous clip, workers are entitled to rights. And this is to curb, especially in the instances of big corporates that have, the powers. This is to curb that corporates and employers take advantage of workers who are in most instances desperate for work. Right. So in a very, very brief nutshell, that is procedural fairness when it comes to dismissals. I get a lot of questions where, for example, I'll make the example about a domestic worker once again. However, I don't mean to be demeaning to domestic workers when I make these examples. Just understand that it's probably the most relatable example to make, which then clarifies the issues being discussed a bit easier. I get a lot of questions from domestic workers where a person will say that my employer decided to tell me on a Friday that is my last day. They told me to pack my things. They gave me my last salary, or not. Some instances they don't give them a salary and they told them to go packing. Like, today's your last day. For whatever reason, the thing about the law is that or labor relations in particular, there is a prescribed process. Even if the reason behind the dismissal is fair, if the process that is followed to lead to the dismissal is unfair, it renders the dismissal unfair. And the employer can be liable for up to 12 months of the employee's salary. So it is quite a sensitive topic, because these are people's livelihoods. But as employers, you have the responsibility not only to safeguard the rights of your employees, but also to ensure that your processes that are in place are in accordance with what the law prescribes. Right. That is where I'm going to leave it for today. If you have any questions you want to send to me in particular, like specific questions relating to any particular matter that you have encountered or any particular situation that you have found yourself in, I am very open to you reaching out to me. My social media, my Instagram handle is @tshego_gailai. You can send me a DM on Instagram. You can also send me a DM on Facebook. My Facebook page is Tshego Gailai, Mrs. South Africa Semi-Finalist 2023. You can also leave me a comment below. Tell me what is your experiences. Let's learn, let's share, let's grow together. Labor lawyers, I would really, really appreciate your engagement. Let's grow together, let's learn together, and let's teach people together. Right? People that are knowledgeable are empowered. So that is my story for today. I hope to see you next time on my little corner of YouTube, particularly my lawyer's corner. And I hope that my information can one day empower you in a situation that you, I hope, don't find yourself in, because who wants to be entangled in disputes and labor matters at work? But I do hope that with the bit of knowledge that we share on my lawyer's corner, you can be empowered, you can be knowledgeable, and you can stay on top of your game. Right, see you next time.